Hi, welcome back to Space Thoughts. It's been a few weeks since I've done a video, and I have a little bit of time, so I thought I'd jump in and talk about something that we hear a lot about, but we really don't understand fully, is the idea of licensing of commercial space activities, particularly in the U.S. Now, when I talk of licensing, I'm talking about authorization, supervision, as it's put out in Article 6 of the Outer Space Treaty. When we talk about commercial space, we automatically think Federal Aviation Administration. They have the authority by Congress, which we'll see in a moment, to license commercial space activities. But what a lot of people don't understand is that there are actually three agencies in the U.S. that license commercial space activities, depending on what activity is being performed. And we're going to go over those three very briefly, what statutes authorize them, some of the regulations, and basically the scope of their authority to do an Article 6 authorization and continuing supervision. So, I think this is important because we all think of just that one agency when it comes to commercial space, but really it's a little bit more than that. And we're going to go to this presentation that I made. I'm going to call it the three rings of commercial space licensing. Now, when I say three rings, I don't mean the three-ring circus, although some people may agree that the process can be like that. But I'm kind of doing a little bit of a Tolkien reference here with the Lord of the Rings. I know there were more than one ring of power, more than three rings of power, but bear with me, and you'll see why this analogy is important as we get towards the end of this video. The first agency that everybody knows about is the Federal Aviation Administration under the Department of Transportation. Everybody that's the most common when we talk about licensing of commercial space. Again, most frequent. We'll go into more depth on how this was actually authorized. Another agency that's tasked with giving Article 6 authorization supervision is NOAA, the National Oceanographic and Atmospheric Administration under the Department of Commerce. And again, they deal a lot with remote sensing, and we'll talk about this a little bit more. And finally, the third one, which a lot of people don't associate with licensing of outer space activities, is the Federal Communications Commission. And this is a real interesting organization in the way they approach their ideal or their philosophy of authorization and supervision. And we'll talk about that a little bit more, but it's very unique how the FCC approaches this and actually justifies being an agency to authorize and supervise outer space activities. We're going to go a little bit more in depth about these three agencies. And again, this isn't going to be a thorough review because this tends to be a very complicated and bureaucratic process, but we're going to just gloss over some of the aspects of each of the agencies. The FCC receives its licensing authorization under Title 51, Chapter 509 of the United States Code. Now, right now, I know there's a debate between who should be, the agency to authorize and supervise these types of activities, whether it should be the FAA or Commerce. And we're going to just stick with the FAA and not talk about Commerce right now because that hasn't been worked out or approved. So for now, the FAA is the agency that licenses and authorizes most commercial space activities. And when I talk about commercial space activities, I talk about, for example, SpaceX. SpaceX is basically that has the COTS program where they resupply for different for the ISS. Those are commercial activities. They have to, in essence, in some respects, they have to get some sort of authorization, even though it is a government mission. For these missions, sometimes they got to go through and be checked through. And other commercial missions, for example, Northrop Grumman's MEV program, their MEV had to go through the FAA, or one of the agencies that had to go through to actually perform the mission that they're currently doing. Regulations for licensing, basically the authority under Title 51, Chapter 509 grants the FAA some limited regulation powers. Now, I know there's a moratorium, a quote, moratorium on regulating the commercial space industry. However, they do have authority in certain respects to regulate it. And those regulations for licensing are found under 14 CFR sections 411 to 416, and then to 1199. Now, I put 1199 in there because that regulatory body hasn't been created yet, but it's being reserved for the point where the FAA does start creating regulations. And again, it gets back to this moratorium. We talk about, for example, space tourism flights. For the FAA has to license those. They don't have the authority to really heavily, how can you say, regulate them, but they do have a licensing authority and some regulations in this. And again, to get an idea of what, we'll get an idea of some of those things as we go on here. Basically, what under the licensing process is basically 3 steps. There's 3 major steps under the FAA authority. First is policy review and approval. And basically what this does is the FAA looks at the proposed space activity and basically compares it to U.S. policy. They go out, they reach out to the State Department, to the EPA, and to other federal agencies to see if this is consistent with U.S. policy, both internally, domestically, and both abroad, internationally. So in other words, what does this proposed space activity present a potential problem with regards to U.S. policy domestically and abroad? Safety review and approval for launch from a federal launch range. Now, understand, all launch ranges are, in a sense, licensed by the FAA. They have to have basically, the sites themselves have to be licensed by the FAA. So basically, also the payload or the proposed mission has to meet certain safety reviews and guidelines, and has to be approved by the FAA as part of this licensing process. And finally, the one we hear a lot about is payload review and determination, whereas the FAA actually looks at the payload that's going to be launched and determines whether this is something that they really want to send into space and such. And the whole idea is we want to make sure that the FAA wants to make sure it's something that's not illegal, or contrary to international law, like a nuclear device or something like that. And that's an extreme example. But the question is, is the private operator intending to send something into space that could affect U.S. National interests or violate international law? So that's part of so that's what happens there. In this point, we're actually looking at the physical payload that's going sent into space at this point. And really, this seems pretty simple, but really it is a long, drawn-out process. And I know right now there is an effort to, quote, streamline the licensing process that basically makes up these three levels. They call it streamlining. I looked at the idea of streamlining. It wasn't really too streamlined to me, in my opinion. So they went back to the drawing board, and apparently the new rules or the new process is going to be coming out probably sometime this fall. So we'll see how that works. The idea behind the FAA's authority covers launch and reentry. In other words, what happens is the FAA issues a launch license. In other words, we're permitting you to launch a payload into outer space, and when necessary, a reentry license. In other words, this is something that's going to come back to Earth. If so, you're going to have to get a reentry license as well. So the FAA's authority covers launch and reentry, but no on-orbit authority. In other words, the FAA doesn't have any jurisdiction or authority over any activities in between launch and reentry. Although through the launch and reentry process, they can kind of control what's going on in orbit. And in essence, that's kind of how you can make sure that nothing, sinister or, outright wrong is going to happen there. There's been a big argument for many years that the FAA should have on-orbit authority. I think they should have on-orbit authority. I think it's part of the whole, authorization and continuing supervision. Although the whole idea of continuing supervision really, kind of tends to be the boogeyman, because, there's a lot of people that, a lot of organizations say, well, this is going to be bad. The government's going to be looking over our shoulder. I don't think that's the case. But on-orbit authority is something that Congress does not want to give the FAA at this point, and it's unclear whether or not it will ever get that, presuming it remains the agency to license commercial space activities. The next one is the National Oceanographic and Atmospheric Administration, NOAA. Now, NOAA's authorization, Article 6 authorization, is relegated to a very, very narrow segment of space activities. The licensing authority for NOAA is authorized by Title 51, Chapter 601. In other words, the same title that the FAA's authority is bound within is also contains the remote sensing for private entities in the same title. They're both in the same title. So that's interesting. This actually used to be part of another statute, the Remote Sensing Act, and it was repealed from that act and actually put under the space activities. Regulations for licensing, 14 CFR sections 960.1 to 960.15, and basically this goes through the whole process of whole evaluation of whether or not a private entity can be allowed to remote sense. And when I say remote sensing, I'm basically saying, are you putting a camera on a CubeSat or satellite or some other spacecraft that can take images of the Earth? And this is where the whole issue of remote sensing comes in. The need for licensing is the NOAA wants to be sure that a private entity isn't going out there and snapping photos of the Earth that it shouldn't be doing. So the idea is it goes through the process of licensing to see if their proposed activities are consistent with U.S. national security interests and other international interests. There's a very onerous the whole idea of remote sensing licensing is what is called shutter control. What a private entity can image, and what data it can obtain, and from that point disperse. And this gets back to is the private entity planning on taking photos of areas that could be very sensitive to the national security of the U.S. or the national security of another country. And that's where the whole remote sensing licensing process got very onerous, is with the idea of shutter control. Now, the regulations for remote sensing were updated effective July 20th of this year to what we call a tier system, where basically the idea behind the tier system is the NOAA will look at the proposed data that's going to be acquired by the private entity's satellite and determine, can this data be obtained from another source, including a domestic or a foreign source. So the idea is, if it's easily obtainable and it's not a big deal, the idea is it may not have to be licensed as much. But if you get a subject matter or data that the private entity is proposing to acquire that is very sensitive and can't be acquired from a foreign source, then there might be an idea of more regulation. And again, that's a very heavily simplified. I kind of fleshed this out in my last quarterly issue, second quarter 2020 issue of my briefing letter, the tier system. But I'll have a link here. You can actually go and read it more about it, about the proposed tier system. Now, it's effective July 20th, but I understand that at this point the updated regulations are still subject to congressional approval. And you can go to the Federal Register at 85 FR 30790, and you can actually see the proposed final rules for the updated remote sensing regulations. So fundamentally, NOAA's Article 6 authorization and supervision authority relates to remote sensing, and that's it. Federal Communications Commission, very interesting organization. I am an amateur licensed radio operator. I have my own call sign. I have a license from the FCC to broadcast over certain bandwidths of the electromagnetic spectrum. But it's very limited based on the license I have. And that's what we think about with the FCC, is licensing of radio and any other areas of spectrum. But it also uses that authority to basically go in and garner Article 6 authorization and supervision authority as well. And basically that authority isn't really explicit, but it's actually implied. Licensing authority, the FAA's licensing authority is implied under the Communications Act of 1934 as amended. And those are all the amendments right there. I'm not going to read through them. You can read them for yourself. In other words, the the FCC has looked at this and said, we are responsible for the spectrum, but satellites in turn use electromagnetic spectrum. So because they use electromagnetic spectrum, we have authority, Article 6 authority over satellites. Now, granted, that makes sense. You know, you would want to have, for example, a communication satellite that sits out in GEO that either transmits, you know, radio signals or satellite TV or what have you. You'd understand, yeah, you're going to have an FCC license in order to use that bandwidth. But what the FCC is saying is, we have more, you know, we have broader authority over satellites because based on that idea that we have control over that spectrum or authority over that spectrum. The regulations for licensing satellites or for space that the FCC has taken is found under 47 CFR sections 25.110 to 25.173. And again, you can go on the internet and you can look these up there. You know, it's nothing secret. These are publicly available and you can read through them. These are the regulations that they have created under their implied authority under the Communications Act of 1934. The authority, the Article 6 authority of authorizing and supervising that the FCC has basically determined it has covers satellite construction, deployment approval, and operations of spares, and it also covers the licensing of ground stations. So in other words, not only are we regulating or supervising the idea of spectrum, but we're also having some say over satellite design, basically, and how they're deployed. And this also goes into the idea of orbital debris mitigation. In that the application for licensing in order to send a satellite a satellite whose primary purpose is communications, in order to send that into orbit, the license requires orbital debris mitigation plans. Now, there's been a lot of media coverage about Starlink, and all these satellites are going up here. In order to actually launch all those satellites, SpaceX has to present a debris mitigation plan to the the FCC, and the FCC has, you know, basically said, well, you know what, we'll accept it for now, but we want you to continue to work on this plan and refine it because we're not quite 100% with it. So the idea is, you know, that the whole idea is the FCC gathers the spectrum, its authority under spectrum to basically cover satellite communications, but satellites themselves, and to mitigate orbital debris as well. So this gives us some pretty broad authority, and even the FAA, for that example, hasn't come right out and say, you know what, we're not going to certify commercial spacecraft. That's just not our purview. Yet here the FCC basically, through its implied authority under the Communications Act, says, we want to see how you're going to construct your satellite, and, you know, we may have some say as whether or not we agree with the way your satellites are constructed. So that's some pretty broad authority that's actually implied through an act that was created before satellites were even thought of. Fundamentally, the FCC has licensing authority for a space activity that's going to primarily involve spectrum, such as communication satellites, or satellites that are going to create internet broadband, along those things. In the case where that is the primary mission, in order to receive a launch license from the FAA, they have to go through the procedures too. But if the primary purpose is spectrum, and the organization receives an FCC license, they're not required to have a payload review under 14 CFR 415.51 to 415.63. In other words, they can skip that step in the FAA approval process. It doesn't happen. It's just not required. And that's actually in regulations, and it's also in the FAA's space licensing regulations as well. So this is like I said, this is pretty broad authority, and it even goes to the point where the FCC presumes it has on-orbit authority. In other words, the FCC says, we have authority of activities between launch and re-entry, and we can basically have a lot of say in how an operator operates their satellites. Now, to what extent does that go? I don't know. Recently, the FAA has updated their orbital debris mitigation rules, and one of the issues that was really hot was what we call indemnification. In other words, there are certain international laws, basically, if there's damage caused by a space object, the U.S. is on the hook. because they are basically the sponsoring state of the private entity. And the FCC is basically saying, in that case, any damages or costs associated with such a claim would have to be borne by the private operator. Now, indemnification didn't make it in this round of the rules, but it's something that's being considered. But the idea is the FCC says we have the ability to say you can indemnify, even though Congress hasn't explicitly given us the authority, we're implying that authority under the Communications Act of 1934 and our on-orbit authority that the Communications Act actually implies. So this is pretty broad authority. Now, not everybody agrees that the FCC has on-orbit authority, and I don't think this has actually been litigated either in administrative courts or otherwise. But this is something the FCC touts, and that's pretty broad authority. And theoretically, it could go to the point where the FCC could actually tell a company, says, you know what, we see by orbital data that your satellite is on a collision course with another satellite, and we want you to move it. Now, I'm not saying that they're going to, but I'm saying this type of authority that they're presuming opens up the possibility that they could actually say that and command an operator to do that, else revoke their license. And one thing I want you to understand with all three of these is these are licenses, and the nature of a license is a license can be revoked. And obviously there is due process, there are appeal processes that have to go through, but in the case of an emergency, or such, that license can be wielded pretty heavily by any of these three agencies, and in particular an agency that has, that claims to have on-orbit authority. One of the interesting about the FCC is it has a very broad reach. For example, if I have a space mission under space mission that's going to be licensed under the FAA, if that mission in any way is going to use any manner of the electromagnetic spectrum, even for ground to spacecraft communications, the operator has to go to the FCC also and get a license. That doesn't mean the FAA is the primary authorizing agency, but what it is saying is because it's using the spectrum and because the FCC has authority over the spectrum, you also have to get a license from the FCC for use of that spectrum. Remote sensing, the same thing. If you have a satellite or a small sat with a camera on board, you are going to take photos, and you probably want to transmit those back down to a ground station. Well, that's great, but in order to on top of getting that remote sensing license, you're going to have to go to the FCC and get a license to operate on that spectrum. So really, in contrast, all these three agencies, they kind of basically form into each other and merge into each other. But if you go back to my Lord of the Rings analogy and the three rings, the FCC in itself is really the one ring that rules them all because it has command over the spectrum or authority over the spectrum. And because of that, it has reach into the other two agencies or any activities that are licensed under that agency. This really is, in my opinion, one of the dominant agencies for licensing, and even though it's just related to spectrum, and most of that authority is actually implied and really not explicitly granted, even though the Communication Act has been amended as I pointed out above. So that's really a quick and dirty explanation of the three U.S. agencies that license commercial space activities. By no means is this legal advice, as I put up in the beginning of my video, and you should obviously, if you're a private space operator looking for to get a license, you should be talking to the FAA or the other agencies to find out whether or not you need a license or not. So please work with them. That's that's their role. And again, it's not my role to tell you yay or nay whether or not you need a license, at least not in the context of an informational video like this. Anyways, if you are celebrating the Labor Day weekend, I hope you enjoy your Labor Day, and we will talk to you next time.